Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Alright, today I'm at Pine Rivers Magistrates Court. Client was charged with drug driving. There's two types of drug driving. The more serious is what's called drive under the influence of a drug. The lesser charge is called drive whilst relevant drug present. My client was charged with the lesser of the two, drive whilst relevant drug present. He was found to have cannabis in his system and he was a P-plater. He wasn't eligible to apply for a drug driving work licence because to be eligible you needed to be the holder of an open Queensland licence, so the fact that he was on his P's means he was not eligible. Worst case scenario, disqualification is a 9-month loss of licence. Mandatory minimum when you're on your P's is 3 months, so it's physically impossible to get any less than 3 months when you're on your P's for this offence. So obviously my job was not one of trying to get a drug driving work licence given he's not eligible. It was one of trying to get the mandatory minimum 3-month disqualification. Given he was a young person, he worked for a company with global ties, and you know his life was ahead of him. He had concerns about the recording of a conviction. Drug driving, it's not a criminal offence, it's a traffic offence. So the impact of a recorded conviction is in no way as severe as that of a criminal matter. Like, to put it in perspective, the only criminal offence that occurs through your matter of driving is dangerous driving. That is an actual criminal offence. Everything else, drink driving, drug driving, careless driving, is what's called a traffic offence, to be said in the same sentence as a speeding ticket. So as you can imagine, a recorded criminal conviction, which you would get for dangerous driving if your lawyer wasn't able to persuade the magistrate not to record a conviction, a recorded criminal conviction is far more severe and has far more impact than a recorded traffic conviction. So, I mean, every speeding ticket anyone's ever had technically had a conviction recorded, and, you know, what did that amount to? Nothing. And no one's ever rang me up saying, you know, I wasn't allowed to, you know, become a doctor, for example, because I had a speeding ticket. And the same applies to any other traffic offence except for dangerous driving. So, drink driving, drug driving, they're all traffic offences. So, the impact of a recorded conviction for drug driving is nowhere near as severe as that of drug criminal offending, so trafficking drugs, possession, etc. So I guess the point I'm getting at is it's not easy to get no conviction recorded for traffic offences. I've got to guide the magistrate through you know, case law, legislation, etc. But the discretion that the magistrate has, it's a broad discretion, and it's a discretion that's only ever triggered in unique circumstances. So whereas with criminal matters, it's quite easy to get no conviction recorded because it's obvious that a recorded conviction can have severe consequences on a person. So, but in any event, notwithstanding what I've just said about the lack of any kind of substantive impact of a recorded drug driving traffic conviction, my client did have concerns in that regard, and so I took it upon myself to make submissions to try to persuade the magistrate not to record a conviction. Excuse me, as far as preparing goes, I got my client to attend the reformatory course that we get all of our clients to do. Got him to get some character references that we provide, a template that we provide to give them to their referees that guides them through who the references are going to be addressed to, the key points that need to be covered. There's no point in going to court and handing up references addressed to whom it may concern, or that don't state that this reference is written in full knowledge of the charge at hand. If the magistrate does not believe that the person who's written the reference knows that it's been written for the purposes of a drug driving charge, for example, or it's written to whom it may concern, and it's, you know, most likely obvious that it's not, you know, written to the court, they'll have no regard of them. So anyway, got him to do that course, got him to get some references. I appeared today, made my verbal submissions about why my client should be given something close, if not dead on, the minimum 3 months, made submissions about why it would be appropriate for the magistrate not to record a conviction. Short version is I was successful on both fronts, so my client received the mandatory minimum of 3 months, no conviction recorded, modest fine, client's very happy, as is his mum. I'm Andrew Wiseman, thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle, imprisonment or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man